legal talk with the jury out of the room. Criminal defense attorney David Seltzer joining us now from Miami to kind of sort this out. So, David, this is sort of an unusual turn of events, isn't it?
Yeah, very unusual. He's not on trial here. The question in and of itself did not call for an answer that would have elicited anything criminal. It's a simple yes or no, and simply answering yes or no would not have affected any of his rights. So it really just depends on the situation here, and the advice that appears the advice he got from counsel was incorrect in this case, because answering that specific question would not have incriminated him. Now, that being said, answering future questions, we don't know the answer to that, but the specific question was posed did not call for that answer.
Well, the judge said, again, when the lawyers were talking after the jury left the room, that he thought it was just some sort of knee-jerk reaction. Maybe he heard felony prosecution and it sort of freaked him out. I mean, do you think it could be just a simple misunderstanding, or there could be more to this?
No, I think it's a simple misunderstanding, and it depends on how his attorney explained him what his immunity is. There are different types of immunity that a witness can get in a criminal case. There's transaction and use. My understanding is he has use immunity, which is a limited immunity, unlike transaction, which is a blanket immunity. Without going into the rules of evidence, I mean, it's a complicated definition for anybody, but if he doesn't understand what his immunity is, that is his knee-jerk reaction. It's better for me to say nothing than to say anything.
Right. The defense is basically trying to get him, this witness, to show that, hey, they looked in the place where Kaylee's remains were ultimately found, as to imply maybe the remains were put there later. So it's something critical to their argument as to who might be behind this, or to try to basically clear their client, right?
Yeah, it gives them a better timeline as to the body, the decomp. It gives them a better understanding as to everything. So they're trying to poke some holes in the case here. They're trying to poke some holes in the timeline. But again, they're doing a little too much, in my opinion, at this point. They have to be better understanding and accepting of their own defense theory. And to me, they're going a little off track.
David Seltzer, thank you so much. Appreciate it. We continue to monitor the trial for you. Stay with us. Robin?